I will do that. That's an interesting link. Yes, Dan really worked that up, and I don't know if you spoke about that a couple of days ago. Was that your topic?
Our driver was bigger and heavier than me, big muscle.
620 pounds at one point.
At one point, but it was my position that at his size, any safety director should have looked at him and submitted him for a policy contract. I mean, he looked up obstructive sleep apnea and you saw his picture. Plus, the driver had falsified his medical long form. He was taking prescription drugs. He had a number of physical impairments that contributed to fatigue and that were a symptom and were a symptom of obstructive sleep apnea. Falsified medical long form, falsified employment application, false testimony in the depositions. We were able to establish him as a person with no credibility, not a likable fellow. In fact, I had him up against the wall somewhat, maybe David on our encounter, but I don't think the driver liked me very much.
No, he told Dan after a barrage of good questions, he basically denied having sleep apnea, which obviously leads to chronic fatigue, which is obviously a violation of the regs, which that was our theory. But he told, I think he made a few smart comments like "nice try, slick" or something like that in the video depo, which came out pretty good. But he's asked directly, "Do you have sleep apnea?" No, and he hedges a little bit. He says no. They file motions for summary judgment against our punitive damage claims, and while those were pending, I just happened to get on the internet and for some reason Googled this guy's name in a different way. And this is the truth. Found a magazine article. He's on the cover of the magazine about several years prior to this crash, a couple years prior to the crash. He had a stomach bypass. He was at 600 and some pounds at that point, and sleep apnea is something that he admitted to in the magazine. We immediately filed that because these are pending. Their defense motions on our punitive damages are pending, so we immediately filed that with the court. Here comes the order, and I've never seen this. Maybe you guys have before. So we were in federal court over in Orlando, and the order read. It didn't read denied. The defendant's motion for summary judgment is denied because we pointed out some other things, including the lying in the medical records. But the judge's order says the defendant's motions for summary judgment are terminated, and we like that ruling, obviously. So we had direct evidence in the medical records. We had an expert, sleep expert, medical professor from Harvard who was wonderful, and their expert, I think, was from Harvard, but he never got tenure and was let go or something like that in the sleep expert. So we had not only the expert testimony, but we had a factual basis to allege it too. But as far as I know, nobody's been successful on a fatigue driving case getting punitives. If I'm wrong, please tell me, because I'd like to understand how your success is. But we had claims against both. Yes. Yes. Are you in Florida? Okay, if you want a copy of the complaint, I'd be happy to do that in the motions and memos. But now, Dan asked me to tell you a story, and again, the level of defense here was pretty intense. I think at lunch, Dan said it was the most complicated case that you've seen. Yeah. And they fought it that way too. I think they were looking at paying nothing at the beginning of this thing because they had such a tight story that they had woven. But we went up to the headquarter town where this company is located to take some depots, and we were staying in the motel. It certainly was not a hotel, and to take some of the depositions. And here comes a bus that was from the same company, and the guy stays in the room next door to us. In fact, the driver comes up and grabs Dan and wants to have a chat with him. So, you know, I froze in my tracks when I saw those two in the breezeway, and of course, I love you, brother, but I was like, I don't think we should be doing that. I think this might be a setup, and I wouldn't doubt it if it was. So you got to really be, there were some other interesting issues that came up that kind of, it looked like kind of a setup to try to get us conflicted out.
He kept trying to engage me in conversation and want to know what we were doing there and that kind of thing, you know. And I said, well, I just kept saying, well, hello. I didn't answer anything, you know. And he just, it was not a casual, hey, how you doing kind of thing. He was literally trying to engage me in a discussion with an employee of the company. And I have no doubt it was all videoed. I mean, this was pretty elaborate stuff.
Yeah, we got actually, we were contacted, my office was contacted over the internet by an alleged current employee. Did not engage in any response, but they were, they tried to enter into a conversation over, through our website, our chat site thing, and you know, we knew better than to respond. And when we tried to track down the email address, or even our IT people who were fairly skilled, there was no way to do it. So you just be careful and just.
Well, we were getting so much traction by this point. They didn't want me in the case anymore, I think, and I don't think they were going to have Dave to be in the case because they started to see the situation turn on, and I have never had a case with more landmines and we would literally spend 15, 18 hours a day looking at different scenarios. It was just focus group the case 5 or 6 times before the first deposition.
Yeah, and you got to do that. And I will tell you that what we see, and you all probably know this, you know, so I apologize, but what you see is these trucking companies and the carriers coming up to you and saying, listen, don't file suit, we want to take care of this, knock this one out early, here's $1 million, okay? And you're listening to the cops, you're looking at the cop statement in the report, you're looking at the witness statements, and you're going, shit, this case isn't even worth $1 million. But I would encourage you not to bite on that. And I think I was in suit on this case within a week of signing the client up, because that's what they're doing now. They're trying to, they create their defense very early on, and they want to mislead you on what the true facts are, and you've got to put the time in and bring somebody like Dan in who's going to work till 3 o'clock in the morning so you can get through that. And they're not just rear enders, and they're not as bad either as the trucking companies' attorneys want to tell you. So, you know, the normal demand period time on these catastrophic injury type cases, while the evidence is withering on the vine, I would encourage you to consider filing suit right out of the gate. Do not take the initial evidence at its face value. You've got to dig and probe deeper on these things. All right, thank you.